Hearing. Item number 8.
I'm appearing for the respondent.
Who is for the petitioner?
So PT. So
So PT Sangma.
you're supposed to file an application, Your Honor.
Oh, that is about that
Yes, sir.
implementation of segregation.
Yes, Your Lordship.
So what is to be done?
I guess they are. He was present in the morning.
Okay. None appears for the petitioner. Mass so and so, just record so and so appears the respondent.
I'm appearing for the all respondent. For the all respondent appeal.
This is matter after 2 weeks.
Much obliged.
Item number 9.
May it please Your Lordship.
Yes.
Lordship, senior conducting.
Mr. Paul will not be available.
He's on legs, Lordship.
He's on legs.
Lordship.
Where?
Before courtroom number 2, Lordship.
I was given an impression yesterday that because of puja he is not free. He is. So that is not correct.
Lordship, that is correct. Lordship, I'm praying if this matter may be listed after puja or vacations.
Okay, Lordship. The only simple thing on last occasion what I raised is that they were insisting if any fault has come up under section 7I, it has to go for appeal. That is like I have raised on last occasion.
There is a provision of appeal.
There is a provision of appeal.
Yes, then that is statutory appeal. That is provided in the statute.
Yes.
So then why you do not avail it?
There is a provision of appeal before CGIT Guwahati.
If that be the thing, you should avail that. Anyway, we'll just have it after
puja.
the request of the learned counsel for the petitioner. This matter after 2 weeks.
Highly obliged, Lordship.
Item number 10.
Here also none appears. This is what, Mr. Kharwanlang?
Lordship,
Quashing.
yes, Lordship.
None appears for the petitioner. Mr. A. Kharwanlang is present for this trip. Moment. List this matter after 3 weeks.
Item number 11. Item number 13.
Yes.
This matter is relating to two villages,
Yes.
and namely Umphanai and Namlair, my lord. So what happened, my lord? There was a boundary dispute. There was a boundary dispute. And then thereafter, in that land of the Namlair, there was a water source also. Then the government, through the CD department, give financial assistance to improve that water source. Meanwhile, my lord, misunderstanding, then so many things happened. Right? So what happened then? There was a damage to that water source. However, my lord, that water source was already, all those things have been rectified, because after the aim of Khairim has settled the matter.
That is a water source maintained by whom? Any of the villages or?
No, it is within the private land, my lord.
That is okay. But then water source, who maintains it? It's a government installation or it is?
No, not government. It's just they give legal assistance, my lord, to improve. That's the only thing. It's not the government land also. However, my lord, all those things have been come to settlement with the decision of the aim of name, aim of Khairim, after both parties have come to understanding. And with that understanding, the whole boundary dispute also have been settled, my lord. And that settlement also have been take effect also, my lord. Then thereafter, my lord, what happened? That prior to that also, because of that damage, is that Umphanai village filed a damage suit before the district council, and that also have been settled, and the order also have been passed accordingly. It has been settled, and practically there is no dispute whatsoever now, and the boundaries have been fully demarcated and duly demarcated and duly recognized by both parties, and now everything has been settled. However, my lord, the parties are willing. They are willing also. They are not willing to proceed this case also. However, my lord, since section
Everything is settled. That what remains? What is the?
The thing is that, my lord, because this.
This is a 482 application.
Yeah, the court issued this application to due to the police case, my lord. Then it was registered under section 3 also of the public damage. Prevention of damage to public property, my lord.
This is an offence against society.
Yes, against society.
There will be bar there.
However, my lord,
You are for?
I am for the private respondent, 2 and 3.
Other village.
Other village.
Other
But
village.
this is a fact, it has been compromised.
Who is it for
we
this
have
thing?
annexed the deed.
State?
and in this case, my lord, there was a similar decision from the Himachal Pradesh, my lord.
Those judgments.
This is not compoundable. Section
One
3.
of the offences is non-compoundable.
What is
But
that?
my
Section
lord,
3.
regarding this, my lord, from Gyan Singh, your lordship,
Yes.
Gyan Singh onwards, the law has been settled. The Gyan Singh, the question came earlier. Some earlier decisions were referred to in Gyan Singh case. There, the indication was this that non-compoundable offence also can be compromised. So when these decisions were placed before Gyan Singh, they expressed their shock. How could it be? When the statute says non-compoundable, they have referred it to a larger bench. Then larger bench examined all those judgments. Then they have laid down the criteria and they said even non-compoundable offence, provided they fall within those guidelines, can be quashed. So that I will satisfy my lord.
But then you see, that also, there also,
Lost.
rider has been put.
My lord.
That the offence,
Lordship.
that must be something,
Yes. No,
it should not be against the society. It is not.
No,
be-
that mental depravity and all those things, that thing will satisfy you, Lordship. We'll go through this.
that is not there. All those things are not there, my lord. Because in that Gansing, paragraph 57
No,
is very
Gansing
clear.
probably it is not correct because that said that even non-compoundable offences can be compounded. But then that has been deferred subsequently, and court said no, you cannot do it. Only 482 can be exercised for quashing in case of settlement.
Yes.
That is what the
Subsequently, I'll rely on a judgment even attempt to murder. There is a case reached the Supreme Court.
307 case.
307 case. There
That is
also Supreme
307
Court has
case. That is
reiterated those same principles.
that is at 2019 or
Satnam
2013 decision. I
Singh.
think. 14 or 19, something like that.
There is, my lord, 2014 6 SSC
Yes, yes.
466. Narinder Singh versus State of Punjab.
Yes. There, but then see that particular paragraph, what it says.
Lordship.
Yes, 307. Normally it said that is a crime against the public. But then even that says that court can go into the thing, take into consideration the nature of injury and maybe the intention and all those
Stage
things.
of the case, in what stage the case
Yes.
is,
But then-
and overall it will lead to what? Like,
Yes.
for example, my lord, I will try to say, boundary dispute, that has been resolved. This is a fallout of the boundary dispute. That has been resolved, compensated, it has been restored, my lord. So larger picture also need to be taken into
If
consideration.
where is the state's the thing becomes quite viral.
If we can suggest, my lord, we continue. In the meantime, perhaps he will finish and come.
No, if that be the thing, I think this has to be decided by taking into question of law only, nothing else.
Yes, I think
See, there is no dispute so far as the
No more dispute.
but then damages to a public property.
that has already been, I think, my lord, settled.
Yes.
It hasn't restored.
In paragraph 57 is very clear, my lord. It is not the offence, if at all the offence, the water source also is in the private property, the resident of my village, is a resident of my village. But of course, all those things we are not related to that because it is a boundary dispute. Boundary dispute has already been settled, and there's nothing more to be agitated, my lord. In this Gansing, my lord, in paragraph 57, my lord, it's very clear.
You've given a list books.
I've given the list.
That is, my lord, 2012 10 SSC 303. In the SSC, it is paragraph 61. I think you have filed a compilation.
Yeah, it is Supreme Court Weekly, SCW.
That is in page, paragraph 57.
57, my lord. Please come soon. Th 39 to 40, madam, in that compile. 39 or 40.
No, what is the page number?
39 or 40.
Yes, 57, Kara 57.
From the middle part of 57, my lord.
Yes, where it is?
However, before exercise of such power, the High Court must have due regard to the nature and gravity of the crime. Heinous and serious offences of mental depravity or offences like murder, rape, dacoity cannot be fittingly quashed, even though the victim of the victim family and the offender have settled the dispute. Such offenders are not private in nature and have serious impact on society. Similarly, any compromise between the victim and offender in relation to offences under the special statute like Prevention of Corruption Act or offences committed by public servant while working in that capacity cannot provide any basis for quashing criminal proceedings involving such offence. But this is what I want to stress, my lord. But the criminal cases having overwhelmingly and predominantly civil flavor stand on different footing for the purpose of quashing, particularly the offences arising from commercial, financial, mercantile, civil. So this is a pure case, my lord, of civil. Or offences arising of matrimony. So on this, my lord, I have relied, because this is a purely civil, original, the boundaries have been already settled, and there is no more dispute, and now everything is all right. And that is done also by the...
It's okay. This court is not doubting the compromise. You see, there is nothing. The problem is what would be the position of law in this regard. That is
The
what.
position of law is very clear, my lord, from in the light of this judgment, my lord. It is a civil, and this I would like to refer, my lord, also that the Himachal Pradesh, my lord, High Court, of course, single bench, similarly like our exactly, then have considered all the law laid down by the Katsina of decision, and this also one of the decision already decided in the light of this decision and many decisions also, the Himachal Pradesh has come to decision. I would like to refer, my lord, to that decision also.
Where is that?
That is in the
compilation.
In the case of High Court of Himachal Pradesh, Bhubaneswari Devi versus State of Himachal Pradesh.
Is it there in the compilation?
Yes, my lord. That item was 6.
Yes.
I will humble and respectfully submit, my lord, that though it is a single bench, my lord, the justice of Himachal Pradesh has considered all these so many judgments, including this.
And what is the relevant part?
The paragraph 7, my lord. Paragraph 7, my lord. Since
Go on.
Since the petition has been filed under Section 482 CRPC, this court deemed it fit to consider the present petition in the light of the judgment passed by the Honorable Apex Court in Arinder Singh and other versus State of Punjab and another Supreme Court, whereby Honorable Apex Court has formulated guidelines for accepting the settlement and quashing the proceeding or refusing to accept the settlement with direction to continue with the criminal proceeding. Then, my President referred to clearly depict para 29.1, the Honorable Apex Court has returned the finding the power conferred under Section 482 of the Court is to be distinguished from the power which lies to the Court to compound offence under Section 320 of the Court. No doubt, under Section 482 of the Court, the High Court has the inherent power to quash the criminal proceeding, even in those cases which are not compoundable, where the parties have settled the matter between themselves. However, this power is to be under, then they have given also that 29, 30, they have given all those things, my lord. And he has referred also to which is in paragraph 8, regarding Gyan Singh, State Punjab. And there also they have referred to Supreme Court decision, my lord. Then, my lord, it come to, in paragraph 9 also, they have referred to the Apex Court in Parvat Bhai Ahir Besos and other Besos, State of Gujarat and another. Then in that paragraph 19, in the consequent decision in State Tamil Nadu versus Basanti Standri also.
No, which
yes.
part will be relevant for you?
Then I will come. Paragraph 12, my lord. In case at hand, offences alleged have been committed by the petitioner do not involve, paragraph 12, my lord, do not involve offences of moral turpitude or any grave or heinous crime. Rather, same as petty offence as such, this court deemed it appropriate to quash the FIR as consequential proceeding. Thereto, especially keeping in view the fact that petitioner and respondent number 2 have compromised the matter, intercede them, in which case possibility of conviction is removed and no fruitful prosper which was saved in counting with the criminal proceeding. Because we heard the fact of this case, my lord, of the Himachal Pradesh is exactly like that. In
14, paragraph 14. There also the section is same under the Act. PDP Act.
Then, my lord, I will quote
Here, who is the accused? Who is accused? In both the cases, in the petitioner and the respondent,
the respondent, the petitioner, my lord.
petitioner is accused.
Yes.
We filed the
Respondent
number two at the relevant time, he was the Sardar. He lodged the FIR. And respondent number 3 is the present Sardar. So all of them are parties in the subsequent compromise deed. The detailed compromise deed, and even at one point of time, there was a suit filed before the SEMO for compensation. Even on the basis of this compromise, even that has been withdrawn.
Not the same kind. That was filed in the subordinate discounsel court. And that also have been compromised. They have been enclosed it here. Now, paragraph 14 also is very relevant, madam. Accordingly, in view of the detailed discussion made herein above, as well as law laid down in the Honorable Apex Court, the FIR so-and-so dated so-and-so under Section 3 of PDP Act. In this case also, Section 3, madam.
This is the only non-comparable.
In this case, this is the only non-comparable. All sections are comparable.
Yes, state. Something requires to be said. What?
I would like to make some suggestions. It's still on next one.
So what is to be done? Somebody else should.
But I rely on this also, my lord. The paragraph 14 is very clear. Because Himachal Pradesh, High Court, my lord.
You just showed it, Section 3 of the PDP Act.
Yes, my lord. And in this case, of course, that also is a government property. Whereas in my case, actually, it's not a government property also, as a matter of fact. But of course, as your Lordship is rightly said, maybe according to with the society, there is no problem. There is no restriction for both the resident of that area to fetch water from that water source. And if you see from the photograph also, as a matter of fact, this is a water source which is not even used now. It was used only during the very, very dry season. And it is not for the whole village, only for that particular locality only. In the matter of the Supreme Court judgment as well as the present case also, madam, it is a fit case that the matter will be, the FIR will be quashed, madam. Yes, the deed of compromise and also I have enclosed, my lord, in this petition in page 89.
There are many petitioners. There are 8 numbers of petitioners.
There were 9, my
No,
lord.
because this is, of course, those are villager only. Because it is,
But they all are accused.
yes, yes. This petition is for all accused. And the previous headman at that also died, and now is a new headman for both sides. So they don't want to continue anymore with this type of fighting, my lord. Otherwise, there's nothing left also. There's no fighting whatsoever. There's no dispute whatsoever. The boundary dispute agreement also is there, my lord, in which the agreement was done before the aim of Hirim. That is in 81, my lord. And the case in district council also which have been compromised, order, see? 75. And in this council. And regarding the damage suit also which they have filed, which have been compromised also, is in page 25 also, we have been closed, my lord. Between the British Darbar Umpanai and the British Darbar Blamlayer. This is between the British, not actually between the individual.
It's all right now. The problem is absence of the state.
Anyway, I approach that order also, my lord, because
After my London senior friend concludes, I'll make my submission in the meantime if he comes.
because in the damage suit also, which I have filed earlier also, there in this council, that also have been compromised, my lord. That order have enclosed in page 25, my lord. And as a matter of fact, it's a very short order. The case is posted today for step and settlement. Both parties are present before me today. The plaintiff filed a petition for withdrawal of the suit number 373 of 32. The parties have come to understanding and amicably settled the matter. Hence, pray for withdrawal. I have perused instant application and also had the Learned Senior Counsel for the defendant. Therefore, in view that the parties in the instant suit have reached an amicable settlement and the plaintiff desire to withdraw the suit, as such I am inclined to allow the instant application. In the light of the above, the instant application is allowed and the instant suit is disposed of. So in the interest of justice, my lord, because that is the most important, I will respectfully submit that the FIR is to be quashed and will be closed once for all, my lord. Itu juga anu juga pisau itu kedul juga itu juga. Sih. Beradab. This was also, my lord, In the petition, the paragraph is given there, page 86, my lord. As it is now, page 86.
The photographs.
Yes, my lord. So that is the water source, my lord.
It's all right. We may not go to that extent.
No, because just I want to impress the court that this is the water source of few residents only, and moreover, everything is already compromised. Here I have written construction of a drinking well amount of rupees 47,000. This is as it is now. It's full of bushes because
No, this compromise has been entered by the Darbar, not by the accused.
no, the accused are a part and parcel of the.
But then they are not a party to the compromise.
They are, my lord.
No, they are not named here.
But, my lord, because the FIR was lodged by the Sardar of the Snong, my lord.
Sardar
And he is
Umpurnai.
a party, my lord.
Sardar Umpurnai.
That's why, my lord, I am representing 2 and 3.
No, what about the accused? It is about the accused, not about. We are not talking about the complainant.
No, that accused number 8, my lord.
Compromise is between two persons only.
No, my lord. It's not, my lord. Accused number 8. Accused number 8 is a Sardar now.
It's all right. It is then, but then if it's a criminal case, if you are saying that there is a compromise in a criminal case, so each and everyone is required to be a party to that.
Because the date of compromise is very much there. Accused number 8 is very much there, my lord.
No, but then what about accused number 1 to 7?
He was. Let me read, my lord, so that everything would be clear.
Yes.
Pandabwar Khasana, son of so aged about 41 years, the accused person number 9, number 9, not number 8, in GR case number 93, hereafter called the second party, whereas the accused number 9 is the headman of Tamdale village, and as such is competent and authorized to swear this affidavit on my behalf and on behalf of Shri Bini
No,
Mawri.
that is what the problem
All
is.
the accused, my lord.
Criminal, how can he represent? Under what authority in a criminal matter?
But for all the accused, he has represented.
He cannot. He cannot.
But when it is a British Darbar matter,
See, criminal law responsibility is individual.
and in this petition also they have signed by all the accused.
No, then they are not a party to this thing.
They are party, man.
To that compromise.
Yeah. This is the criminal. Yes. Even between the village, no? That is a mere technical matter. Otherwise, all of them have signed, matter.
It is not technically, Mr. Kinji. If we had not signed this petition but then had signed the agreement, okay.
They signed the petition also.
But then, if you say compromise, then it has to, basically it is required, then because they are the accused.
The petition before this court they have signed. And then we are more to sign now, because after all, that is a compromise matter.
What is the case of thing that stage of the trial?
Trial is, it is there.
This charge sheeted or not?
Charge sheeted, of course.
But then what is the stage of the trial?
Framing charge, constitution for charge, my lord.
When was charge sheet filed?
Page 29, my lord. 29. And the chance to for conviction also is practically zero, my lord.
Charge sheet dated, my lord, 1/7/2020.
1/7?
2020.
2020. So now it is already 3 years.
But it has not otherwise, my lord, proceeded, my lord.
Is there any statement on a petition, in your petition, about that thing? It's nothing.
No, still not.
Because if you go through the
That of course, my lord, what is the
These are
position, my lord?
certain facts which has to be there before the court.
But
It should not be something like that they pass an order after that is
I
disposed.
understand fully, my lord, the constraint. Now, so far these two reservations, my lord, have one, whether all the accused have signed, and what is the state. Now, for what is the state, my lord, learned additional advocate general can always apply. And secondly, my lord, on the point that all of them had not signed. But lordship will look into the tone and tenor of the settlement. This has been finally settled by the two villages. Now, only for the signature it should not fail. Why, my lord? Because lordship, this petition, my lord, filed by all the 8 accused. Then we have been made a party. Now I am representing both the previous Sardar and the present Sardar. Now we are saying, my lord, this has been compromised. So lordship can take note of it. Only for the reason it should not fail. And regarding the stage, of course, my lord, the additional advocation can always apprise the courts.
So how long court
As
will
per the
wait for
instruction I have received, my lord, it has not made any headway. It is not at the, my lord, middle of the trial.
I don't know if the court exactly remembers. The last occasion, the learned AG had some objection. He was raising.
Yes, he is saying, my lord, this is damaging public property. Now, lordship will look into this thing also, my lord. It is on record. Some kind of, my lord, assistance was received from the videos amounting to 47,000 or something, my lord. It's a very paltry amount. Whatever it may be, my lord, that was damaged. But this has been restored.
It is not that they mean public property doesn't mean that the state has control over it or not.
Not necessarily.
If you say the property, you see, whether what is the
belongs to society.
yes, that is what.
But society as a whole won't compromise, my lord.
End of the day, my lord, what is there in that Narendra Singh and other case, your lordships? End of the day, your lordship will look into, number one, is it a heinous crimes, my lord, resulting into moral depravity or moral turpitude, your lordships? That is the, my lord, consideration, lordship. It is not, my lord. And the larger picture, if you look into it, my lord, they had a, my lord, for a long time, some kind of dispute, boundary dispute. That has been resolved, your lordship. And a part of it, my lord, this particular issue has also been compromised.
If you go through, my lord, from the statement of the complainant also, which is on page 66, my lord, 66, then it very clearly show that everything will be clear, my lord. Page 66. Page 66. On examining him in connection with the above referred case, he stated as follows: my name so and so and so. And then he received a telephone from Grunting Malbanyang, who is chairman of Nondalom, informing Grunting Malbanyang, who is the chairman of Nondalom, who informed me that the villager of Lamdair village, the villager of Lamdair, on being led, my lord, by the Sodar of Lamdair, had come to destroy the source of water at Umpranai village, which was newly constructed under the CD scheme 1516, issued by the BDO Malukane. And on receipt of information, I, along with Grunting Malbanyang, chairman, had gone to the spot, and the way we met the villager of Lamdair village. And when we reached our spot, we found that entirely new construction supply from source was totally destroyed. The third construction of source of water supply cost at about rupees 47,000 only. That was sanctioned by the BDO Malukane. The third water supply fall under jurisdiction of Pranay. However, there was no restriction for use of water supply to residents of Lamdair also. Thereafter, on the same day in the evening at about 7 p.m., an urgent meeting so and so had held with regard to the illegal action by the SORA, and the residents of Lamdair were involved in the said act, and decision that came out of the committee to file FIR against the SORA of Lamdair. As a matter of fact, the FIR was filed against the then SORA of the villager for that, and that then SORA, of course, is dead, my lord. Hence, I filed FIR Madarting police station on 21/12/2007. The FIR does not state all these people, my lord, because this is under the then leadership of the then Saudar, my lord. So it clearly shows, my lord, that this is a case between the Saudar of Lamdair and the Saudar of Umpranai, my lord.
We'll have it some other day.
And that Sodar the then Sodar who led them at that time expired on 4/11/2020, my lord. That was given page 77 of the petition. In any view of the matter, my lord,
We'll have to have it after. Not today.
Okay, Lordship.
In absence of Mr. Shulai, it will be.
He's not finished yet.
We'll have it after a week. It's all right. There is no problem now. The only thing is that without he being present,
No, I'll not ask him. Should not be. He's the more. He will have to say, my lord. Only thing, otherwise, my lord, these I don't know, my lord. Whatever law placed by my landers, these are the things covered the field. Now, my lord, my humble submission, of course, my lord, I have not made my submission. Your lordship pardon me on the next day. I'll just show, my lord, this comes within the parameters laid down by those decisions. Moral depravity, of course, it is not. Paltry amount, your lordship. And larger consequences, lordship. Lordship will look into it. This is very common, my lord, boundary dispute. That has been resolved. And as a consequence, these are also stand resolved. So, my lord, all these things are there, your lordships.
okay.
And as regards, my lord, this settlement, my lord, I think all the parties are here and we are considering there is a settlement. I think that should not be a factor because all signatures are not there in the settlement.
Can I heard Mr. S. Kinjing, London Senior Counsel, assisted by also Mr. S. N. London Counsel appear for the response number 2.
Two entry.
Mr. Please give your name. Appearing for the state respondent submits that Mr. Andy Shulai, he submits that, yes, Mr. Andy Shulai, who is appearing this matter, is not available. Stop in view of the submission. List this matter after a week.
Will remain part of it.
What is the news?
Let
We'll
it
not
be
keep
part of
anything
your
part.
lordship.
So it will come up like this. See, this court has.
No, otherwise what happened? No, otherwise, my lord, only thing I'm facing this difficulty is what happened. Matters are substantially heard, my lord, and if it is not noted as part heard, what happened, your lordship, it will come in normal course. So far, in the list is concerned. So, my lord, there might be other matters.
Every day, this court touches the last item. Nothing is.
No, I'm not saying this, my lord. Then it what happens.
And
my
this is not going to any other court. It will remain here.
lord. All right.
No more.